I would like to submit that the 4 commissioners were fully justified in saying we cannot own results we have not tallied and we have not verified. The law has been referred to this honorable court severally, that it is the commission that should do the verification and the tally. This legal notice that appointed the chair as the returning officer, you've been invited to hold that legal notice, that regulation is unconstitutional and valid because it contradicts the Constitution and the Elections Act. But beyond that, it is the chair himself alone who appointed himself as the returning officer for the presidential elections. You will not find any minutes of any meeting by the commission appointing the returning officer. So quite apart from the fact that it was unconstitutional, it did not have the authority of the commission. I would like to cede ground to my colleague Apollo so that we operate within the 60 minutes accorded to us. I ask that this court upholds the position of the 4 commissioners, that the results that were announced were not the results tallied and verified by the commission. I thank you.
The Chief Justice and members of the court, without wasting more time, I'll pick it up from where the senior counsel has left. My name is Apollo Mboya. I am on record for the fifth respondent. Your Ladyship and my lords, the actions of the chairman of the Electoral Commission can be evaluated using several instruments. And I believe the first instrument that we need to use in examining the whole issues that are before this court is the oath that the commissioners take. The oath is in the 3rd schedule of the IEBC Act, so that for every action we juxtapose that oath to those actions, so that we test if the actions meets the tenets of that oath. And permit me to read what that oath says, and it's taken by all the commissioners. It states, I, then they say their name, having been appointed chairperson or member, as it can be, of the Independent Electoral and Boundaries Commission, do solemnly swear that I will at all times obey, respect, and uphold the Constitution of Kenya and all other laws of the Republic of Kenya. That is the oath they take. That I will faithfully and fully, impartially, and to the best of my ability discharge that trust and perform the functions and exercise the powers devolving upon me by virtue of the appointment without fear, favor, bias, affection, ill will, or prejudice. That is the promise that they are giving to the people of Kenya and to the whole world. Now, for every action that the chairman did, which I'll not go into because this particular affidavit of the 5th respondent has been cross-referenced by my other senior counsel and also learned colleagues who spoke before me. We juxtapose those actions against that oath that they took. So, for example, if we are talking about issuing a gazette notice You look at that Gazette notice with the law, then juxtapose it to the oath, if it meets that promise that they gave. Your Ladyship and my Lords, the fifth respondent is now affectionately called opaque. Affectionately. I say that because arising out of what transpired at the National Tallying Center, the four issued a statement in which they said they cannot own the results that were going to be announced by the chairman, and therefore they were opaque. Your Ladyship and my Lords, that term opaque is not coming from the ordinary. It's a term that was given by the Court of Appeal when they were making a decision in another matter, which is now famous here, called the MATIANG'I matter, which when they were looking at the role of the chairman vis-a-vis the other commissioners. And the court did indicate that to suggest that one individual alone can tally and verify the votes for presidential election is to suggest otherwise, to introduce opaqueness and arbitrariness to the electoral process. Those were the words of that court. Members of the court, we might ask if the chairman, as indicated from the affidavits that we have had, that it was his responsibility alone to tally and verify the results, then the question is, what were the other commissioners supposed to be doing on that election day? Were they supposed to sit at home and watch the screens just like any other Kenyans? But then again, the chairman went ahead and allocated them duties. With respect to the fifth respondent was given the role of media. In that role, the fifth respondent was supposed to explain even to the media why what they were reading, the results they were reading, are not being projected on the screens. The results that they read were not projected from Friday 13th. And when that question was put to the chairman to refresh, the chairman said, no, I'm tallying from the back end. Your Ladyship and my Lords, the sum total of this whole transaction is that the chairman usurped the powers of the commission. And it's our submission that after all is said and done, and after we get the reports of the verification, I believe that this court will arrive at a conclusion that the chairman of the Electoral Commission was actually an agent of a presidential candidate. That presidential candidate we will know by 5th of September. And if that's going to be the case, lastly, it's our submission that this court must go further and look at the theory of agency. All the conspirators that did any illegalities all irregularities are agents of one another. The person who benefited from those irregularities and illegalities is a co-conspirator with the persons who perpetrated it, and they are agents of one another. And for that reason, we would urge that this court makes appropriate decision with that particular issue in mind. I call upon my learned colleague, Jotham Arua, to take over from me. Thank you very much.
The Honorable Chief Justice and the honorable members of the court, my name is Jotham Arua. I appear for the 7th respondent, Commissioner Justice Nyang'aya. I will be making submissions on the following issues. Issue number 2, whether there was interference with the uploading and transmission of Form 34As. I'll also speak to the issue whether there were irregularities and whether the irregularities affected the results. I'll mention briefly something to do with the reliefs that this court ought to make, and also issue number 6, whether IBC carried out the verification exercise. So on the first issue, my lady and the honorable members of the court, the position of my client is that there were indeed interference with the uploading and transmission of Form 34As. My client maintains that this was done without the involvement of the commissioners, specifically the 4 commissioners. And it is their position, my lady and the honorable members, that it was done in clear violation of Article 81E of the Constitution and Article 86. Before I proceed, I wish to clarify that we have made reference to a number of authorities in our written submissions, but I will not refer to them because of time constraints. As regards interference with the ICT infrastructure, the Commissioner, in his affidavit, which has been filed before this court, and specifically in paragraphs 33 to 34, raises a number of issues. First, he maintains, my lady and the honorable members, that the server was accessed by unauthorized persons, and these included foreigners and some members of the IEBC. He mentions them by name. He further maintains that one foreigner by the name Gudino Omar accessed the server several times. He explains that a number of forms were pulled down and others uploaded. And he also maintains that there was revision of Form 34Bs. My lady and the honorable members, these allegations are contained in his affidavit, and I wish to point out that they have been responded to by IEBC. In their response, the first thing I wish to point out is that there is no denial that the logs that he annexed to his affidavit emanated from IEBC. The only contention being raised is how did he get them? That contention, in our humble submission, has no merit, considering, as he puts in his affidavit, that he was the commissioner in charge of ICT at the commission. If a commissioner who is in charge of ICT cannot access that kind of information, it is my submission that nobody else in IEBC can access them. The next thing that, and that admission, Madam Chief Justice and the honorable members, is found in the affidavit of Hilda Kavonga. That affidavit is filed by the firm of Iseme Kamau and Maema Advocates and is sworn on 27th of August 2022. And the admission is contained in paragraph 13, Roman 4. Beyond that, Madam Chief Justice and the honorable members, there is also an admission, and this, according to me, is a serious admission. There is an admission that the server was accessed by a foreigner by the name Gudino Omar, as mentioned in the affidavit of Justice Nyang'aya. But I wish to read to the court what he said as concerns this foreigner. At page 5, paragraph 13.7 of her affidavit, that is Hilda Kavonga, she says, Gudino Omar is the technical lead for Smartmatic, who provides support on the technical.